All right, so today we're taking a deep dive into something I think a lot of renters out there have probably dealt with at some point. It's landlord-tenant disputes, and specifically, we're going to be looking at ways to resolve those disagreements without having to go through the whole court process.
Yeah, it can be a real headache for tenants, right? Disputes with landlords can be super stressful, and not everyone knows what their options are.
Exactly, and sometimes going to court is unavoidable. But the sources we've been looking at, things like briefing documents and articles on landlord-tenant issues, they all point to a few key alternative methods that tenants can try first before things escalate to that level. We're talking about things like mediation, for example. And, for tenants in Orange County, Riverside, San Diego, or Los Angeles who are dealing with eviction, unlawful detainer actions, or premises liability issues in their apartments.
The Martinez Law Center in Santa Ana specializes in those areas.
Right, exactly. They focus on representing tenants, and their website is martinezlawcenter.com if anyone wants to check them out. But today, our mission is really to equip you with the knowledge to hopefully avoid even getting to that point of needing a lawyer, if possible.
Absolutely. Early intervention is key, and that starts with understanding your options.
So let's jump right into it. For a tenant who's facing a dispute with their landlord, what exactly is mediation, and how does it typically work?
Mediation, well, it's essentially a way to resolve things outside of court. It's a non-binding process, which is super important for tenants to know. Basically, you and your landlord agree to sit down with a neutral third party called a mediator who helps you both communicate and try to come to a solution.
Okay, so this mediator, they're not like a judge, right? They don't make a ruling.
Exactly. They don't have the power to force a decision on either side. Their role is more like a facilitator, someone who guides the conversation, helps clarify issues, and maybe suggest possible compromises. But ultimately, it's up to the tenant and the landlord to reach an agreement.
So if it's not like a court hearing, what does a typical mediation session actually look like?
Usually you start with a joint meeting where both the tenant and the landlord get to explain their perspective on the dispute. They lay out the issues, what they think happened, and what they're hoping to achieve.
Got it. So everyone gets their say.
Right. Now, sometimes just having that initial conversation is enough to reach a resolution. But if not, the mediator might use a technique called caucusing. This is where they meet separately with each party one-on-one.
Oh, interesting. So they kind of go back and forth.
Yeah, in a way. During caucuses, the mediator can help each side clarify their position, brainstorm options, and then they relay offers and counteroffers back and forth between the tenant and landlord. The goal is to bridge the gap and find some common ground.
Okay, that makes sense. And throughout this whole process, it sounds a lot less formal than, say, a court hearing.
Definitely. Mediation is designed to be more relaxed and conversational, which can help people feel less defensive and more open to finding solutions.
So what are the biggest advantages for a tenant who chooses mediation over taking their landlord to court?
Well, first and foremost, it's way more cost-effective. You're not racking up legal fees at this stage. And since it tends to be much quicker than going through the court system...
You save money on those legal fees, too.
Exactly. Faster resolution, fewer expenses, it's a win-win. Plus, mediation is confidential. Whatever you discuss in those sessions stays private, which can be really important for both parties.
Privacy is definitely a big factor in these kinds of situations. Any other reasons why mediation might be a good option for tenants?
Absolutely. It encourages collaboration rather than confrontation. Instead of one side winning and the other losing, mediation aims to find a solution that works for both parties. That can mean coming up with creative solutions that a judge might not even consider, like a flexible payment plan or an agreement on a specific timeline for repairs.
Oh, I see. So it's more tailored to individual circumstances.
Yeah, it can be. And because you're actively involved in creating the solution, it can feel more empowering for tenants. They feel heard, and the outcome is more likely to feel fair.
That's a great point. So it's not just about resolving the immediate dispute, it's about finding a solution that actually works for everyone. And you mentioned something earlier about sometimes uncovering deeper issues in mediation.
Yeah, sometimes the specific issue that brings you to mediation, like a broken appliance or a disagreement about rent, it's really just a symptom of a larger problem. Like maybe there's a pattern of neglect on the landlord's part or communication breakdowns. In mediation, those underlying issues can come to light.
So it can be more comprehensive, more about fixing the root of the problem, not just the surface issue?
Exactly. It's about finding long-lasting resolutions. For example, imagine a tenant is frustrated about a leaky faucet. But during mediation, it comes out that several other tenants are experiencing similar maintenance issues. The landlord might agree to a building-wide maintenance overhaul as part of the mediation agreement.
Wow, that's a much bigger impact than just fixing one leaky faucet.
Right. It addresses the core problem, not just a single instance of it.
Oh.
So, yeah, mediation can be really effective in that way.
Okay, so let's say a tenant is facing a dispute with their landlord. Before they even consider mediation, what should be their very first step?
All the information we looked at stressed this. Negotiation. Always try to talk directly with your landlord first. See if you can resolve the issue yourselves, one-on-one.
Makes sense. It's often the simplest and most direct route. So how should a tenant approach this initial negotiation? What are some key strategies they should keep in mind?
Well, before even talking to the landlord, the tenant should be clear on what they want to achieve. Define the desired outcome, set a bottom line, know where you're willing to compromise. And when you're ready to talk, try to choose a neutral location, a quiet place where you can both speak openly and be heard without interruptions.
Okay, setting the stage for a productive conversation. What about the conversation itself? Any tips for how to navigate that?
Active listening is crucial. Let your landlord express their concerns fully, without interrupting, even if you disagree. Summarize their points to show you've understood. It can go a long way in preventing misunderstandings and making them feel heard.
That's good advice in any conversation, really.
Definitely. It shows respect and that you're approaching it as a problem to be solved together, not a battle to be won.
Now, while being respectful, it's also important to be firm, right? Especially if the tenant knows they're in the right.
Absolutely. Be polite, but be clear about your position. If you have documentation or legal precedent to back you up, use it. State your case clearly and confidently.
And avoid getting emotional or making personal attacks.
Right, that never helps. Stay calm, focused on the issue at hand. Remember, you're aiming for a solution, not an argument.
And what about if you do manage to reach an agreement through this negotiation?
Put everything in writing. Immediately. This is so important. Every detail of the agreement, clearly written out, signed by both parties. Ideally, the tenant should volunteer to draft this document just to ensure accuracy.
That makes sense. Control the narrative, make sure it reflects what was actually agreed upon.
Exactly. If money is involved, the agreement should state that the payment fully settles the landlord's claim for that particular issue. You want everything spelled out, no room for ambiguity later.
Now, we've been focusing on negotiation and mediation, but they're not always the answer, are they? Are there situations where these just aren't the right approach for a tenant?
Definitely. There are some situations where going straight to court might be necessary, like if the dispute involves really complex legal issues or if there's a huge power imbalance that makes it impossible to negotiate fairly.
I see. What are some other scenarios where a tenant might want to consider alternatives to negotiation and mediation?
Especially if a tenant believes they've been discriminated against. If the landlord's actions seem to be based on race, gender, religion, disability, any protected characteristic, those are red flags.
Those are serious allegations. What's the best course of action in those situations?
The sources recommend filing a complaint with a fair housing agency, or potentially even taking legal action. It's about protecting your rights and addressing potential discrimination head-on.
So while negotiation and mediation are great tools, it's important to know when they might not be enough.
Exactly. There are times when you need a different approach.
Now, earlier we mentioned arbitration. It's another term that often comes up in these discussions, and sometimes people confuse it with mediation. Could you clarify the difference between the two?
Sure. The key difference is that mediation is non-binding, meaning the mediator doesn't make the final decision. Arbitration, on the other hand, is binding. It's like mini-court, where both sides present their case to an arbitrator, and that arbitrator issues a decision that's legally enforceable.
So like a judge, but outside of the actual court system.
Exactly. And honestly, arbitration is pretty real in residential landlord-tenant disputes.
Good to know. Now, let's say a tenant decides that mediation sounds like the way to go. How do they actually find mediation services in their area? Where do they start?
Lots of resources are available. A good starting point is community mediation programs. Many cities and counties offer these, often for free or very low cost.
Those sound great, especially for tenants who might be facing financial constraints.
Right. You can usually find info about them through your city or county government websites, or just search online for community mediation in your area. Professional organizations like the American Arbitration Association can also offer referrals.
And what about colleges and universities?
Yeah, some of them offer mediation services, especially in areas with a lot of student housing. Check with student housing offices or legal aid clinics at local universities.
Lots of options to explore, it seems. Now, the sources we looked at also talked about why mediation tends to be so effective in resolving landlord-tenant disputes. What are the reasons behind that success?
Well, part of it is just the willingness of both parties to participate. By agreeing to mediation, they're saying they're open to finding a solution that works for everyone. And because there's no judge imposing a decision, it creates a less adversarial atmosphere. People are less defensive, more willing to listen and compromise.
It takes the pressure off, allows for more open communication.
Exactly. And as we discussed before, that ability to explore underlying issues and come up with creative solutions, that's huge. It can lead to more comprehensive and lasting resolutions.
Makes sense. Addressing the root causes, not just putting a Band-Aid on the symptoms.
Right, exactly. So even though we spent most of our time on these alternatives, let's touch briefly on litigation. What are the situations where a tenant might need to go to court?
When do those other options just not cut it?
Sometimes litigation is the only way to get a legally binding resolution. Like if the landlord has seriously violated the lease agreement, or if they're refusing to comply with the law in some way.
So it's the last resort when all else fails. And what are the drawbacks for tenants who have to go this route?
Well, it can be expensive, with attorney fees and court costs. It's time-consuming, dragging on for months or even years. Plus, it's inherently adversarial, which can further damage the relationship with the landlord.
Not ideal, for sure. And everything becomes public record in court, right?
Yeah. So there's a loss of privacy, too. It's something to weigh carefully. But of course, litigation does have its place.
Right. Sometimes it's the only way to enforce your rights and get justice.
Exactly. When other options have been exhausted or just aren't appropriate for the situation, going to court might be the necessary step.
So as we wrap up this deep dive, what are the key takeaways you want our listeners to remember?
Always try direct negotiation with your landlord first. If that doesn't work, explore mediation. It's a powerful tool, often cheaper, faster, and less stressful than litigation. It's confidential, collaborative, and can lead to more creative solutions.
And it's empowering for tenants, giving them a voice in the process.
Absolutely.
Yeah.
But remember, these alternatives aren't always the answer. If there's discrimination involved or if the legal issues are really complex, seek legal advice or consider filing a complaint. Know your rights and know when you need to take a different approach.
Great advice. So for any renters out there facing a dispute, weigh your options carefully. See if direct communication or mediation might be a good fit for your situation. And if you're in Orange County, Riverside, San Diego, or Los Angeles, and you're dealing with eviction, unlawful detainer, or premises liability issues.
The Martinez Law Center in Santa Ana focuses on representing tenants.
Right. You can find more information on their website, martinezlawcenter.com. All right, that wraps up our deep dive for today. Thanks for listening.
Thanks for having me.
Call now 714-442-9741. Thank you.